Now I would like to welcome our special guest, Mr. Arijit Prasad, Senior Advocate, Supreme Court of India. Sir is a senior advocate in the Supreme Court of India. He is the youngest and the second advocate from the Northeast to be designated this position. Sir was born to the former Assam Minister, Mr. Vishnu Prasad. Sir has completed his BCom from Delhi University, LLM in Corporate and Tax Laws from London School of Economics and Political Science. Sir, please address the gathering and share your wisdom with us.
Thank you very much. It gives me a great pleasure to be amongst you all this afternoon. I'm very happy to know that the Institute of Law is organizing the Dipak Misra National Moot Court Competition, and it has been organizing moot court competitions for a very long time now. I myself was a very keen mooter. I participated and represented Delhi University in many moots. So mooting is the foundation for a lawyer to be in litigation. Mooting is a very popular co-curricular activity in law schools. Mooting not only helps improving your researching, drafting, and oratory skills, but it also develops a lot of soft skills like confidence, communication, teamwork, etc. The moot court is a replica of a real court proceedings. The purpose of moot court competition is to make students aware of the court proceedings related to dispute between parties. These competitions are organized mostly in law schools for students who wish to pursue their careers in litigation, become judge, or be arbitrators. This practice helps in the development of legal skills, research acumen, and speaking skill. The process of mooting is not the same as public speaking or debating. Moot courts are more interactive in nature, and there is cross-questioning. Moot court, the participants have to pursue the judges and show them what their legal case is all about. Generally, the moot courts have two teams, the defendants and the respondents. The mooting presents a hypothetical case, and both teams are required to research it and represent their arguments. The mooting culture began in India somewhere around the beginning of 1980s, and since then has been used as a tool of persuasive advocacy to train the future generation of lawyers. When a problem is presented to the mooters are supposed to read through the problem carefully. The facts, the initial judgment may not seem very favorable to you, and you may start feeling like you are really up against it. Just remember, moot problems are designed to test your ability to think on your feet and articulate arguments. They're designed not to be easy, otherwise wouldn't everyone be studying law? Determine what area of law would you have to deal with and what specific topic is being addressed in the problem. What was the decision of the lower court? What were the reasons for its decision? And what legal authorities or principles that were applied and you were relying upon? These authorities or principles will provide you with a platform for understanding the initial decision, preparing your legal arguments. You have to see which side are you on. You'll be told whether you are appearing for the appellant or the respondent. You'll also have to determine with you and your moot partner what ground of appeal you are dealing with. Read through it in full, all the legal authorities that have been relied upon to reach the decision in the lower court or the judgment which you are appealing. The key to being a good advocate is to identify the strength in your arguments as well as the weaknesses. Being prepared in this way will mean that you are not caught off guard in responding to judicial interventions, and then you will be able to identify the strength and weaknesses in your opponents. Consider how the authorities have been interpreted and applied. Make a list of case law and any other relevant legal authorities. This was the preparatory part of it. Then on the day of the moot, when you are before the judges, be confident. Even great advocates aren't perfect, and not every case is a winner. But presenting your arguments with assurance and speaking in a clear, forthright tone makes all the difference. Be prepared for all level of judges, or all kinds of judges. You never really know in advance if you have a judge who has looked at your brief and a judge who is an expert in the area of law which you are going to argue. Learn to read a judge's comfort level with the material and adjust the detail and complexity of your arguments accordingly. Persuasion isn't always the art of having the most details. It's about your knowledge and your knowledge about your audience and tailoring your message as such. Lead with your strongest point rather than building up to it. You should have an outline of your argument and be ready to proceed if you're not interrupted early. It's unlikely that you'll get through most of your remarks as prepared. Accordingly, be sure to amplify the most important aspect of the case at the start and try to articulate the theme of your argument in the first sentence or two. Be able to steer the conversation by smoothly transitioning between the questions and arguments. Doing so also creates a convincing yet conversational style that puts judges at ease. Where possible, weave into your arguments the idea that you are not only correct on the law, but also seeking a just result. Although focused on the legal analysis, the judges are attuned to fairness considerations and can be persuaded by them in a closed case. When asked a question, answer it directly. When possible, start with a yes or no. But if the answer is something which is against you, then you have to think what to say and slowly take him to which is your stronger point. Mooting enables the student to engage with and think deeply about interesting and topical legal issues, to enhance their advocacy, legal research and writing skills, and to be part of a team effort, to demonstrate their interest in advocacy and competence as an advocate of prospective employers. Most students find mooting to be intellectually rewarding and highly enjoyable. It can be at the beginning nerve-wracking and frustrating, but it's a lot of fun. This is what lawyers do every day in and out, somebody who does litigation. It's critical to engage with the bench. This requires you to bring many skills together, including maintaining eye contact with the judge, speaking at an appropriate volume and pace, responding directly and accurately to questions, and holding the judge's interest. It also incorporates a cardinal rule of mooting: never ever talk while the judge is talking. This holds even true in real life when we argue matters with people. Try to understand what is the question and answer accordingly. Remember that it is accepted to ask a judge to repeat a question if you do not understand it, and that it is always best to say, "I regret I am unable to assist your lordships," on the point when you really do not know the answer. Mooting is not just about presenting propositions of law. An important aspect is applying those propositions to the facts in order to argue for the result you want. You should be very familiar with the moot problem and be able to take the judge to a relevant paragraph. You will often make extensive use of authority in delivering your submissions. You need to know what principle a given case stands for. If the case is binding on the court, the moot is being argued. A critical aspect of moot is time management. You need to be able to expand or contract a submission depending on how interventionist the judge is. You should never repeat, and you should come up with an answer which is to the point. Mooting is the foundation for young lawyers, young law students. The more you moot, the more you become attuned to arguing a matter. And this will hold you very, very beneficial in the long run. I'm sure all the young mooters here today are going to be good lawyers when they join the bar. I'm wishing you all the best to all the participants and the winners. Thank you very much.